Hello and welcome to Topic 8, Lecture 1. And in this lecture, we're going to be learning about the organization of the federal courts. So what are we going to be covering in this lecture? Well, first, we're going to learn about the role the judiciary plays in American government. Next, we're going to look at the different types of cases and laws that come to courts, learning the difference between civil law and criminal law. We're going to talk about the different types of courts that make up court systems, both the federal court system and the state court system. So we'll be learning about the difference between trial, appellate, and Supreme Courts. And then finally, we'll take a look at how the court system is organized in the United States. So let's go ahead and get started. So as you know, we're in the unit where we're learning about the institutions of government. We just got done with learning about the lawmaking, the federal lawmaking branch, Congress, and we know that the major role that they play in American government is passing laws. That we've learned about the executive branch, which is comprised of the president and the bureaucracy. And we know that the main thing that they do is take the laws that are passed in Congress and put them into action, to enact them, to execute the law. That's why they're called the executive branch. So what is the role of the federal courts? What do the courts do in American government? Well, the main thing that they do is that they apply the law, okay? So the law is passed, the law is enacted, and then the court is there to make sure that the law is followed, that it applies the law to the actions of those who are in the United States. So what does it mean to apply the law? Well, one thing that the courts do is they interpret the meaning of law, okay? And so when there are laws on the books and there are disputes, another thing that the courts do is they settle disputes. But when there's a dispute over the meaning of the law, what does this law mean? And does it apply to the actions in this case? The courts will, interpret the meaning of laws. Both federal laws, sometimes state laws, at the highest point, the court, in particular the Supreme Court, will interpret the meaning of the Constitution because that is the highest law of the land. Then the court applies laws to the case that's in front of them, and oftentimes when they apply a law, they apply it in a way that is reflective of past decisions that the courts have made. And that's what is known as precedent. That in our judicial system, that when a court makes a decision, future courts or present courts look back at those past decisions and use it to guide their present decision making. Okay, they use those precedents to decide their decision making. And that's what's known as stare decisis. Stare decisis is the idea of letting the decision stand, okay? That's what that means in Latin. Stare decisis means let the decision stand. And so basically what that means is that if we've decided that this case one way in the past, then we're going to let that decision stand and use it to guide our decision making in the future. As we know that particularly the Supreme Court, the lower appellate courts are bound by precedent, but the Supreme Court of the United States can overturn precedent, as they just did in the Dobbs case, overturning the precedent of Roe v. Wade. But in general, the courts are guided by past precedent. Let's use an example to bring some of these concepts to light. And so today, in fact, the Supreme Court is hearing oral arguments about universities that consider race as a part of their admissions process to universities. So they're looking at a case that deals with both Harvard University, but also the University of North Carolina. And if you read the news this week, you'll see cases. You'll see some articles about those oral arguments. And what those cases are about is whether or not the policies and the practices and the laws allowing state universities to use affirmative action, whether or not that's constitutional, okay? And so what the court is doing is that the Supreme Court is looking at the laws and the policies that are governing the actions of the University of North Carolina, and they're looking at those policies and practices, and they're interpreting the meaning of those policies and practices. How are they used? But more importantly, they're looking at those practices and those policies, and they're asking the question, does the use of affirmative action, does taking race into consideration, one thing among many things that might be considered when admitting somebody to a university, does that violate the Equal Protection Clause? Because as we know, the Equal Protection Clause says that no state shall deny any person within its jurisdiction the equal protection of the law. And so the Supreme Court is interpreting what that means. Does the equal protection of law mean that you have to that laws and policies have to be colorblind, that they cannot take race into consideration at all? Or in some circumstances, does the Equal Protection Clause allow for race to be taken into consideration when admitting people into college? We'll find out the answer to that question later on, but it's a good example of how courts interpret the law, apply the law as they understand it, and look to back to previous decisions precedent to drive their decision making. There is a court case called Grutter v. Bollinger that basically says that it's okay to use race as one feature of other factors that are taken into consideration when admitting somebody into college. It's very likely that the court is not going to use that precedent in this case that they're hearing now. They very well may overturn precedent, but we'll see what happens. So laws can fall into several different categories, but the two main categories that of law are what are known as criminal law and civil law. And so let's just talk about the difference between criminal law and civil law, because it helps us understand how our court systems are organized. And it's also just good to know the difference so that as you are learning about the courts and maybe even sitting in and watching some court procedures, that you can understand the difference between criminal and civil law. Criminal law is the kind of law that defines conduct that is not allowed. In other words, it prohibits some kinds of conduct. It says if you engage in this conduct, you have committed a crime. So good examples of criminal law are, sexual assault. If criminal law will define what sexual assault is in state or federal statutes. That's usually something that's left to the states. And they will say that this is what sexual assault is. It'll define it. And then it says if you engage in this behavior, you've committed a crime. And then it tells us a little bit about what the penalty for that crime is going to be. Burglary, murder, petty theft. All of those are examples of criminal law. That the dispute that is settled in criminal law is a dispute between the state and an individual. And so when you look at criminal cases, that criminal cases will always be the state versus the individual. And so here it could be the state of Wisconsin versus Bob Smith. Okay, if you see a court case that says Wisconsin v. Bob Smith, it means it's a criminal case. It could also say the United States versus Bob Smith. And then that would mean that the individual Bob Smith would have committed a federal offense. Okay? And so basically the state is saying that an individual has engaged in this crime, that they have violated the criminal laws of Wisconsin. And then the dispute is the defendant, right? So the Wisconsin would be the prosecution. Bob Smith would be the defendant. The defendant would dispute this claim that Wisconsin is making. They would say, no, I didn't commit this crime. You got the wrong guy, right? Or what I did was not, was actually not sexual assault as it's defined, right? And so it's the courts that settle that dispute. The court decides, is this person guilty of a crime or are they not guilty of a crime? Okay, and so in criminal law, it's a determination of guilt that's going on, and it's the state that has to prove that the accused is guilty, and there's a relatively high standard that is used. The evidentiary standard for criminal law is beyond a reasonable doubt. And so for the state to prove that Bob Smith is guilty as charged, they must prove that that person is guilty beyond a reasonable doubt. And so, we have a high evidentiary standard for criminal law because really bad things can happen to you if you are found guilty, right? You could be incarcerated. You could even be subject to the death penalty. So we want to be confident that the person who is charged with the crime is in fact guilty. Civil law is different. That civil law revolves around settling a dispute between individuals or between an individual and an organization. Some examples of civil law are suing somebody for breach of contract, okay? So let's say that you have a contract with somebody. Let's say that you've signed a contract with a landscaping company to come to your house and plant a tree and to plant some new grass seed, some spring bulbs, what have you. And then you say, okay, I agree to pay you X number of dollars to do this. And then you agree to plant these things and you agree to do it by this date. You both sign on the line. And then, let's say that the landscaping company doesn't complete the job. Well, the homeowner, the other, person who signed the contract could sue the landscaping company for breach of contract. And it would go to the courts to decide, who's the responsible party. And so in criminal law, it's not about who's guilty, but it's who's the responsible party, who's responsible for breaking the contract, or who's responsible for causing this dispute. So in the case of the contract, you could say, the landscape company might come back and say, well, we didn't finish the job because in the contract it said that they were going to pay us $100 up front and $100 at the conclusion of the job, and they never paid $100 up front. So that was part of the contract. And so that's what the court would do. They would settle that dispute over that disagreement. As it says, there's no criminal penalty. In civil law, you're not, if you're found to be the responsible party, you're not sent to jail. But that you can be asked to pay, not asked, but the court will demand that you provide compensation for the damages that ensued from breaching the contract. The evidentiary standard is lower. It's by a preponderance of evidence. And also, oftentimes in civil law, you don't need to have a unanimous jury decision. And so the bars are lower because the consequences of being found responsible are somewhat less. So let's apply what we've learned here about the difference between criminal and civil law on the next slide. Okay, so let's apply what we've learned from the last slide about the difference between civil and criminal law. So we're looking at these examples. Ask yourself, do you think this is a matter that is primarily a civil matter, a matter dealing with civil law, or do you think it is a matter dealing with criminal law, or maybe it could be both? So here's the first one. How about somebody fails to pay rent? Is that primarily a civil matter or a criminal matter? The answer is that it is a civil law. Why? Because it's a breach of contract, and it's probably one of the most frequent types of civil law cases. So when if you don't pay your rent, you can't be sent to jail for not paying your rent, not yet anyways. But you can be sued by your landlord for not paying your rent. But you could say, look, I didn't pay my rent because my apartment, they in the contract it said that they would keep it clean and that they would deal with any pest problems, and the landlord hasn't done that, and that's why I didn't pay my rent. But regardless, it is a civil matter. How about knowingly making false statements to harm somebody's character? That's known as defamation. So if you're saying false things, you're knowingly saying false things to really hurt somebody, is that a criminal or a civil matter? And an example of that is just a recent case with Alex Jones, right? The conspiracy theorist who was knowingly putting things out online on the internet that was making up false statements about the parents and children that died in the school shooting in Sandy Hook. Civil or criminal? That's a civil matter, okay? Defamation, knowingly harming the reputation of somebody else, that's a civil matter. So Alex Jones won't go to jail for that, but the jury awarded him $1 billion to repair the damages that he caused to the families of the victims of Sandy Hook. How about knowingly making false statements in court under oath? So when you're testifying in court, you raise your hand, you take an oath. What if you go on the stand and you make false statements? Is that a criminal matter or is that a civil matter? Well, if you said criminal, you are correct. That's a crime to do that. There are laws, it's known as perjury, and there are criminal laws that saying if you engage in that behavior, you've engaged in a crime, and the penalty for perjury can be pretty severe. Hunting a federally protected wildlife, is that a criminal law or is that civil law? If you said criminal, you are correct. That there are federal laws in place that say if you go out and you're hunting and kill an eagle, a federally protected wildlife, you've committed a federal crime and there will be a penalty. How about willful failure to pay child support? Okay, so you get a divorce, and in the divorce, it's determined that you are the parent of the child and that you are the one who is not going to be living with the child, so you're responsible for paying for their custody. What if you fail to pay that? Is that something that somebody would sue you for, a breach of contract, or is that a crime? It's actually a crime. In the federal law, under Bill Clinton, in order to up the pressure on people to actually pay child support, they passed a federal law saying that if you didn't pay it, that you could be subject to criminal penalties. How about copyright violation? Say you steal somebody's artwork, or you steal somebody's song, or you engage in you steal somebody's patent and use it and claim that it's yours. Is that a civil violation, a criminal violation? Well, if you said both, you're right. Copyright violation is a violation of federal law, and it is also, somebody can sue you for using their art or their music that they produced. You could sue them for the damage that comes from taking that person's intellectual property without your permission. So hopefully that helps you understand the difference between those two categories of law. All right, so now let's take a look at the American system of justice and some core principles to keep in mind, and then we'll move on to take a look at the organization of the court system in the United States. So one thing to keep in mind when you're learning about the federal judiciary is that in the United States, the federal law is the supreme law of the land. And that comes from Article 6, Section 2, which is the Supremacy Clause. And it states that federal law, or what it means is that federal law takes precedent over state law. And so whenever federal law and state law come into contradiction with each other, when they conflict each other, federal law is supreme. So concrete example, you have state laws that legalize marijuana for recreational use, and federal law, marijuana is still a controlled substance. So that is the federal law making it a marijuana controlled substance. That is what's supreme. And if the Drug Enforcement Administration wanted to come and mobilize its agency to take down pot dispensaries in Illinois or Colorado or whatever, they could legally do that. They don't do that. They could if they wanted to. Why? Because of the Supremacy Clause. So keep that in mind as we're learning about how the federal courts, or how the court system in the United States is organized. Another thing I want you to keep in mind is a federalism. Okay, so the United States is a federal system, and so that we know that power is shared, but that because of the 10th Amendment, the police powers, remember the police powers that come from the 10th Amendment, that basically says that when it comes to regulating the behavior and the morality of people, okay, that power falls to the state. So the vast majority of criminal law falls to the state. So, if you engage in murder, if you engage in sexual assault, if you engage in burglary, for the most part, you're violating a state law. It doesn't mean there's not some federal dimension to it. If you murder somebody, put them in your car and then drive over state lines, like murder, in Waukesha, and put them in the trunk of your car and then drive to Chicago or something like that, then federal law is triggered because the federal law has jurisdiction over crimes that go between state lines. But for the most part, criminal law is reserved for the states. And keep that in mind as we're looking at the organizations, because as it says there, these principles are reflected in how the court system in the United States is organized. So let's take a look at how the court system is organized. Okay, so this is a rough diagram that shows you the organization of the federal courts. Now, to learn more about the details of the federal courts, I'll touch on it briefly in lecture, but make sure that you read in your textbook about the purpose and organization of the federal courts. And then also there's a really cool Vox video for you to watch this week, which is about 5 minutes long, that does a great overview of the organization of the federal courts. But just simply let me put on my pen here. Okay, so on this side, this is the federal court system. Okay. And there are different courts, there are different federal courts. The lowest level federal courts are known as the U.S. district courts. Every state has at least one district court. This is the trial courts, and we'll learn more about that in a second. Just keep that in your noggin, that the U.S. district courts are trial courts. And if you break federal law, federal criminal law, or if you are engaged in a lawsuit that is between two states, this is where you're going to end up. Okay. This next level is the U.S. Federal Court of Appeals. So there are 94 U.S. district courts, at least one in each state. Wisconsin has 2. And then there is also the U.S. Court of Appeals. And so if you don't like the outcome of your trial, then you will appeal it in the U.S. Court of Appeals. Okay. And then, so this is the federal side. This is the state side. Every state has its own unique state court system. And so here, you have state trial courts, state intermediate appellate courts, and state supreme courts. How these are organized and how many of there are in each of the states, that's determined by state law. So Wisconsin has its own state court system. Minnesota does, Illinois, that's unique to the states. But this is generally there's the trial courts, the intermediate appellate courts, and a state supreme court. So you sort of see, hey, that, on federalism, if it's a federal law, you're going to go on this side of the court system. If you break state law, that you are going to go on this side of the court system. And this side of the court system is super busy, particularly because of criminal law. Criminal law is handled almost primarily, not primarily, but mostly by the state court side. Okay. But note here at the top that the top court of the land is the Supreme Court of the United States, which we're going to be learning about in the next lecture. And this is the court it's the court of last resort. It makes final decisions about the constitutionality of law, okay? And so if there is a state court case, criminal case, that triggers something in the Constitution, so let's say that you're charged with the crime and tried and found guilty, but that you feel like the evidence was improperly collected, therefore a violation of the Fourth Amendment's unreasonable search and seizure clause, then you could say, wait a second, the Fourth Amendment was violated. And then you could take it to the state appellate court and they could determine that. But that's ultimately going to make its way over to the federal court system because it deals with some aspect of federal law, in this case, the Constitution of the United States. And so that since federal law is the supreme law of the land, that the decisions that the Supreme Court make, in particularly about the constitutionality of both state, federal, and local laws, they have the last say. It's the court of last resort because federal law is supreme. So on that last slide, you were, basically seeing a rough overview of how the court system is organized in the United States. And I was making reference to trial courts, appellate courts, right, Supreme Courts. Let's dig in and look more precisely at what each of those different levels of courts do. So the lowest level of the court is what is known as trial courts. They're known as the courts of original jurisdiction. And the reason it's known as the court of original jurisdiction is because that means that trial courts hear the case for the very first time. It's the first court to hear the case. And there are civil trial courts, and so that have trials over disputes between individuals, like the Alex Jones case, and obviously there are criminal trial courts as well. So what takes place in the trial court? Well, the trial takes place in the trial court. Although I teach the criminal justice as well, and there's a lot more things that take place in the trial courts than just trials. But basically, that the trial courts are where trials take place. Evidence will, you're settling the dispute about whether or not somebody is guilty of violating criminal law or responsible for some sort of breach of contract of some sort of aspect of civil law. It's in the trial court where evidence is presented, where you hear testimony from witnesses. There's a jury that will render a verdict, right? And render a verdict of guilty or not guilty. They don't render a verdict of innocence. And so if you've been following the Darrell Brooks trial that just ended in the last 2 weeks, great example of a state level trial court. So what's the difference between a trial court and an appellate court? Well, an appellate court does not hear cases for the first time. They only hear cases on review, okay? And so that after a decision is made in the trial court, a decision of guilt or responsibility, as in civil cases, if the person who's found guilty doesn't like that outcome, they can appeal that case to the appellate court. Now, the state in a criminal case cannot, if it's a determination of not guilty, the case ends there. The state can't be like, well, we don't like the not guilty verdict, right? That we're going to take it to the appellate court and, ask for a redo. That violates double jeopardy, right? The Fifth Amendment. And so there is the state cannot appeal a not guilty verdict, okay? But in a civil case, there's appeals that can happen on both sides because each side of the case is found to be responsible or not responsible, and you can appeal that. And so the appellate court hears the appeals of the trial court. There's not a trial, lawyers present briefs. Usually they do a panel of judges. There's usually one court. There's one judge in trial courts. There are multiple judges at the appellate court, 3, sometimes as much as 9 with the Supreme Court. They read the briefs, and then based on the briefs, these written reasons for why the decision of the lower court should be affirmed. This person is guilty and you should affirm that decision. The other side will submit briefs saying, nope, this person's not guilty, that you should either send it back for retrial or vacate the decision of the lower court. That's what happens in the appellate court. They correct errors. There's no testimony. It relies on court records and briefs for the justices to make their decision. And then the Supreme Court, as it says there, it's the highest court in the system. It usually serves as an appellate court function. It usually doesn't hear cases for the first time. And so it's basically the final check. It checks and reviews the decisions of the appellate court and renders a final decision. So let's take a look at the diagram again so that we can apply these concepts to what we saw on that diagram. Okay, so back to the diagram, you can see that the U.S. district courts, those are the federal trial courts. This is the court of original jurisdiction. This is where a trial takes place if you violate federal criminal code. State trial courts, that's where the trial takes place if you violated state criminal statute or if there is some sort of civil matter that is taking place. That if you don't like the decision in the U.S. District Court, you would take it to the U.S. Court of Appeals. This is the Intermediate Court of Appeals. Trials don't take place there. It's a review of the decision of the lower court. And same with the state appellate courts. They review the decision of the lower trial courts. But keep in mind, if the decision of the trial court implicates some aspect of the Constitution, it can go over to the federal side, okay? Now, if it's not dealing with the federal matter, but let's say it's dealing with an interpretation of the Wisconsin Wisconsin Constitution, that kind of case would go to the state Supreme Court, okay? Of Wisconsin, all states have a Supreme Court. They make the final determination as it relates to state law, okay? But it's the federal, the U.S. Supreme Court, the court of last resort. They're the ones who make the final determination regarding the constitutionality of laws in the United States. Okay, so hopefully this lecture gave you a better understanding of the different types of courts that are in court systems, and also get a somewhat of an understanding of the organization of the court system in the United States. So make sure that you watch that short video from Vox about how a court, about learning more about the organization of the federal courts, and also it talks about how a case makes its way to the Supreme Court. That's in your textbook, but the video gives you a nice overview before you read it in the textbook. And in the next lecture, we're going to focus on the United States Supreme Court. Thanks for your time, and I'll talk to you again soon.